independence, we pray Thee, grant us the grace to respect each other this day in all our consultations, that our deliberations today shall take place in the spirit of mutual trust, so that we as leaders shall lead our country on the path of peace and shall find solutions for issues and problems facing us. Grant us the mercy, O Lord, that we shall today also honor Thy name in all we think, do, and say. Almighty God, we pray Thee, bless our land and all its people. This all we pray in the name of Jesus Christ our Lord. Amen. Let's solemnly affirm that I will be faithful to the Republic of Namibia and its people, and I solemnly promise to uphold and defend the Constitution and the laws of the Republic of Namibia to the best of my ability. Please be seated. Yeah, I have some announcement. The first one is that the Standing Committee on Rules, Order, and Internal Arrangement, in principles, agreed with the request for the extension of the sitting days and times of the session to consider the urgent proposed bill or bills. We said in principle there is a somehow condition attached to that, and that the next paragraph said, therefore, the meeting humbly, with respect, requests the Minister of Justice to give indication by the latest Monday, the 10th of March 2025, at least by 11 o'clock, that the bill will be ready for tabling. Is it okay? So agreed. It means now from Monday up to Friday, we extend the sitting rather than Tuesday, Wednesday, and Thursday. We are also going to extend the time to enable us to finalize those requested bill. So agreed. A second announcement is that the National Assembly, in collaboration with the High Commissions of various Commonwealth countries represented in Namibia, are organizing the commemoration of the Commonwealth Day, scheduled for Monday the 10th March 2025 at 9 o'clock at the normal place outside the chamber there of the National Assembly. I therefore invite all honorable members to join the Speaker in commemorating the Commonwealth Day at 9 o'clock. The 10th. No, normally, I should think if you are going to have a sitting, Monday should be in the afternoon, whereas Friday should be the morning hours. Do we understand in that place? Yeah. Monday is that's why I said the Honorable Minister must indicate by at least 11 that the bill is ready. And then in the afternoon, Monday, 14:30, we sit. Whereas Friday is in the morning, 9 o'clock. Henceforth, the Commonwealth Day is 9 o'clock in the morning. So informed. Is there a problem to inform you, colleague, and invite you? Okay. The Dr. Honorable Minister of Higher Education, you have some urgent point to raise? Can you stand up? Can you stand up?
If you could repeat what we were saying as a directive.
Which one?
Everything.
The first announcement is dealing with the extension of the sitting of this parliament from Monday to Friday. And we requested the Minister of Justice to finalize the bill by 11 o'clock, because it doesn't help us to come, people to prepare, and then the bill is not finalized. Okay. That is announcement number one. Number two, you want to hear it again. Number two, you are invited to the Commonwealth Day. It's a normal practice that Namibia, part of the Commonwealth, they do commemorate this how do you call it? Yeah, Commonwealth Day. Scheduled, this time is scheduled for Monday, the 10th, at 9 o'clock. The sitting is in the afternoon, 14:30. Correct? Saba? Yeah, the other issue will wait up to Monday. Okay, report of standing or select committees, other reports and papers. The report of a standing and select committee, I recognize Honorable Murorwa.
Thank you very much, Honorable Deputy Speaker. Honorable Deputy Speaker, honorable members, I raise to motivate 5 reports. And please, yes, 5. That's what you said. Should I motivate?
Just a moment, eh?
Yeah? Which one?
Yeah, can you look at because we were not yesterday there, it is on the other paper, number 2.
Don't have it here. So, this is only notice.
Today, number 2.
Okay. Thank you.
Okay. Thank you. I recognize Honorable Chair, Chekero Chair.
Honorable Deputy Speaker, honorable members, I lay upon the table the following reports of the Standing Committee on Natural Resources. 1. Report on the study visit to the Parliament of the Federal Democratic Republic of Ethiopia for note-taking. The second, report for the petition to provide for the regulation of foreign ownership of land in Namibia for consideration and adoption. Third, report on the motion to find solutions to the devastating effects of the increasing seal populations on the sustainable harvesting of fish stocks in Namibia for consideration and adoption. 4. Report on the oversight visit to the resettlement farms in Ochodonjupa, Omaheke, Kunene, and Erongo regions for consideration and adoption. 5. Report on the oversight visit to the mining and energy companies in Oshikoto, Ochodonjupa, and Erongo regions for consideration and adoption. And 6. Report on the oversight visit to the conservancies in Kunene and Zambezi regions for considerations and discussions. I so move, Honorable Deputy Speaker.
Yes, thank you. Please table those reports. Yeah. Any tabling of further. I recognize Honorable Katamelo.
Thank you, Honorable Speaker, honorable members. With humility, I stand to give notice that on Tuesday, the 11th of March, the year of 2025, I shall move that this Assembly amend Rule 2, which provides for the establishment of a select committee in terms of the rules of the establishing, functioning, and procedures of committees. So I move, Honorable Speaker.
Okay, yes.
In the same breath, I've got another one. On behalf of the Budget and Finance Committee, I move that this Assembly discuss the drought assistance measures as provided to farmers through Agribank by the Ministry of Finance and State-owned enterprises, and also discuss the full implementation of the recommendation of the Standing Committee on Economics, Public Administration, on Financial Institutions and Markets Act, in short, FIMA. So I move, Honorable Speaker.
When are you going to?
This one, I move the rules. It's on the 11th of March 2025. The other one of the Standing Committee on Budget and Finance is on Wednesday, the 12th of March this year.
Okay.
My apologies. I remember I did not.
Yeah.
I omitted the date.
This is actually supposed to be notice of motion. Isn't it?
That's why it's pink, Honorable Speaker.
We are not yet there. A moment. We are not yet there. Because I have to go to the other reports and paper. We were just done with a report. And then the next one is other reports and papers. Notice of questions. Notice of questions is followed by notice of motion. Then you stand up. No. Notices of questions. Notice of questions. I recognize Honorable Dirhar.
Honorable Deputy Speaker, I hereby give notice that on Thursday, the 13th of March, 2025, I shall ask the Minister of Information and Communication Technology, Honorable Emma Theophilus, the following. The dangers of fake news on social media platforms like Facebook, TikTok, X, and Instagram are significant, as it can spread rapidly, reaching a wide audience before it can be corrected. Misinformation can mislead people, incite fear, and perpetuate harmful stereotypes or false beliefs. On a larger scale, it can disrupt political processes, promote racism and tribalism, and undermine trust in public institutions. Social media's viral nature makes it easier for fake news to influence opinions, manipulate emotions, and polarize communities, all of which can have long-lasting societal consequences. I therefore wish to ask the Honourable Minister the following. What legal framework does Namibia have in place to address the spread of fake news, and how does it apply to individuals and media outlets? Second, what are the potential consequences for individuals found guilty of spreading false information in Namibia? Thirdly, are there specific laws or guidelines that define what constitutes fake news in Namibia and how do authorities ensure consistency in enforcement. Fourthly, how does the government balance the fight against fake news with the protection of free speech and press freedom in Namibia? Number 5, what role does your ministry play in monitoring and addressing the spread of misinformation, particularly on social media platforms? Number 6, how does the government plan to collaborate with technology companies, social media platforms, and other stakeholders in the fight against fake news? And lastly, has there been any public awareness campaign or educational efforts to inform citizens about the legal implications of spreading fake news? I so submit, Honourable Deputy Speaker.
Please table the set of questions. Next, Honourable Friss.
Honourable Deputy Speaker, I hereby give notice that on Thursday, the 13th of March 2025, I shall ask the Minister of Environment and Tourism, Honourable Pohamba Shifeta, the following. Sports betting in Namibia poses significant social and economic risks, particularly among young people and low-income communities. The easy access to sports betting and gambling platforms has led to a rise in gambling addiction, causing financial distress, broken families, and mental health issues such as anxiety and depression. Many people chase losses, leading to reckless spending and debt. Without strict regulations and public awareness campaigns, the growing sports betting industry in Namibia could have long-term negative consequences on the Namibian society. I therefore wish to ask the Honourable Minister the following. Number 1, what measures is the government taking to combat unlicensed gambling and sports betting operators in Namibia? Question number 2, how does the ministry regulate gambling and sports betting operators to ensure responsible gambling? Question number 3, there is a major concern of minors taking part in sports betting and gambling. What laws are currently in place to prevent minors from engaging in sports betting and gambling in Namibia? Fourthly, what penalties exist for operators who allow underage sports betting and gambling in Namibia? Number 5, are there age verification measures in place at different betting shops and online platforms? Question number 6, are there specific policies in place to address gambling addiction in Namibia? And the last question, Honourable Deputy Speaker, how can communities and organizations collaborate with the government to tackle gambling addiction in Namibia? I so submit, Honourable Deputy Speaker.
Please table the set of questions. Next one is Honourable Mororo.
Thank you very much, Honourable Deputy Speaker. I hereby move that on Thursday, the 13th of March 2025, I shall ask the Minister of Agriculture, Water and Land Reform, Honourable Carlos Ledwine, the following questions. Honourable Speaker, Honourable Deputy Speaker, Honourable Minister, on 13th February 2025, you informed the Namibian nation through this August House, in your own words, that your ministry is persistently receiving requests from traditional authorities for expansion of traditional authority communal areas due to unavailability of grazing area for their livestock. Your ministry responded positively to those requests by acquiring the following farms with the purpose to relieve grazing pressure on communal areas. A. Remaining extent of portion A of the farm Orongava number 72, measuring 15,116.19 hectares. This farm will be added to Ochimbingwe communal area. B. Farm Osema number 63, measuring 5,374.39 hectares. This farm will be added to Ovitoto communal area. And C. Farm Guzinde number 197, measuring 3,753.93 hectares. This farm will also be added to Ovitoto communal area. And D. Farm Alpha number 628, measuring 6,767.6098 hectares. This farm will be added to Aminui's communal area. I therefore ask the following questions. Why did you appeal, 1, to this August House to support and approve the initiative of expanding communal area to enhance the living conditions of the Namibians, while knowing that the farms Osema number 63 and Farm Guzinde number 197 were advertised by your own ministry as a single unit recommended to be used for game farming only and not for grazing of livestock, as you have falsely informed this August House and the nation, or to be added to the communal area of Ovitoto? Number 2, did you rezone this farm from going to be used as a game farm to a livestock grazing farm with an indication of livestock as per the carrying capacity of it to fit into the requirements of the communal grazing area? 3, can you provide an official newspaper advert to that effect to this August House? Number 4, when did you take the decision to expand the Ovitoto communal area, and who advised you to do that, since the request by traditional authorities to expand their grazing area is the request made by many traditional authorities to the government of Namibia? 5, why did you not inform this August House and the nation at large that there is a legal battle around the allocation of these farms, Osema number 63 and Guzinde number 197, lodged with the Lands Tribunal of Namibia by the aggrieved appellant Chobesi Game Farming Safari Sisi? Are you aware that the fact that you wrote a lease termination letter to a beneficiary who has been occupying the said farms for nearly 8 years on 18 April 2024, the attachment is attached here, and it is a letter that is also signed by you. Are you aware that the Land Tribunal of Namibia expressed itself on this case number LT0002/2017, attachment B? The attachment B is also here. And then number 8, could you please explain to this August House your interpretation of the final decision of the Tribunal of Namibia of setting aside the decision of the minister, and the appeal succeeds with cause on attorney and client scale? Do you agree, number 9, that the appellant in this case is Chobesi Game Farming and Safari Sisi, and that they have won the case? Number 10, Do you agree that you communicate with Chobesi Game Farm and Safari CC on 5th of August 2024 and that you promised to revert back to them once a decision has been made? Attachment C, which is also here. Number 10, do you agree? Number 11, would you agree with me, and I quote from that letter, in the light of the above, you are advised that the matter is being dealt with administratively, and once the decision has been reached, the ministry will inform you accordingly as in attachment C. This, in my opinion, means that as much as you, on the basis of the decision of the Land Tribunal, wrote a termination letter to Ovitoto Game and Hunting Safaris Pty Limited as the previous beneficiaries, you now, according to the very same decision, is deemed to inform the successful Avalanche Chobesi Game Farming and Safaris in this case, and that they are now the beneficiaries of Farm Osema number 63 and Guzinde number 197, and thus has to be issued by you with a lease agreement letter. Number 12, have you reached an agreement with Chobesi Game Farming and Safari CC that they are no longer going to pursue this case? If so, please provide evidence to that effect. 13, if it is not the case, please inform this August House what the logical ending of this case is. Number 14, did you inform Chobesi Game Farming and Safari CC accordingly as you promised before you tabled the intention of the government to expand the communal area of Ovitoto in Ochodonjuba? Yes, number 15. Do you, as Minister of Agriculture, Water and Land Reform, have any legal standing to disregard the decisions of the Land Tribunal of Namibia? Would you please provide proof if there is any? Number 16. We are coming to 20. Would you please inform this August House how you are going to honor the decision of the Land Tribunal immediately before your retirement? Because we know you are going to retire on the 21st of March this month. Number 17, when do you intend to withdraw your tabling of the farm number 63 and farm Guzinde 197 in this August House? Number 18, would you agree with me that if it does not happen, the withdrawal, then you have not only failed to correctly inform the Parliament the whole truth, but you also misguide the President to gazette farms by way of proclamation and gazetting them while the Land Tribunal Court has decided on differently. Number 19, how else are you going to reinstate the character of the President of Namibia, His Excellency Dr. Nangolo Mbumba, before his retirement on 21st of March 2025 with this issue? Because he is now going to make a farm, there's a proclamation going to come out from him on a farm that the Land Tribunal has decided on otherwise. Number 19, how else are you going to reinstate the character of President that is finished. And 2019, do you want the President to retire with a blot of corruption on his character?
No, let's...
I so move.
Have your question.
You wanted me to...
Yeah, table the question.
You wanted me to continue?
No, I wanted to comment on.
You wanted to
Yeah,
comment?
no, table your questions, please, Honorable Muroro. Yeah, that is the end of questions, I think. The end of questions, I think. Notices of motions. Then I give the floor to Honorable Katamero.
Yeah?
Honorable Speaker, since it's a repetition, but for the record, I give notice that I will lay upon the table on Tuesday, the 11th of March 2025, that the Assembly discuss the amended rule number 2, which provides for the establishment of selection committee in terms of the rules on the establishment and functioning procedures of committee. So I move.
Okay.
Also on the same day, I will lay upon the table the report of the Budget and Finance Standing Committee to discuss the drought measures as provided to farmers through Agribank by the Ministry of Finance and State Enterprises, and also discuss the full implementation of the recommendation of the Standing Committee on Economics and Public Administration on the Financial Institution and Markets Act, in short been called FIMA. So I move, Honorable Speaker.
Please table your motions. Message from the head of state. Another motion. Okay, I recognize Honorable Hambiga.
Honorable Deputy Speaker, honorable members, I move without notice that leave of absence be granted to Honorable Lucia Ipumbu until further notice. I so move. Honorable Deputy Speaker, there is another second one. Honorable members, I move without notice that a leave of absence be granted to Honorable Tony Noyoma until further notice. I so submit, Honorable Deputy Speaker.
Yeah, table them. Two motions. The head of state message was not there. Ministerial statement. We will move to the order paper of the day. Or we have to decide. Sorry? If you look on order paper, you like us to go to questions or to question or to the order papers? Okay. Where? The first question, question number 63, is by Honorable Benz of PDM to the Deputy Prime Minister and the Minister of Work and Transport. Would you like to put the question?
Say yes.
You would like to put the question, Honorable?
I put it through. I put it through.
Sorry?
Yes, that is correct.
Question.
I put the question that is
Honorable Member,
Yes,
just say I put the
I
question.
put the question, Honorable
Okay, thank you.
Deputy Speaker.
Honorable Deputy Minister of Work and Transport. Is it within your ambit or is it within the, he asked, or it's, Can we have it? Yeah, it falls within your portfolio as a Deputy Minister of Work and Transport. The question, as I read it, have nothing to do with his function as a Deputy Prime Minister. We normally do that. I put question number 65. I put question number 65. It was put by Honorable Chiramba. Both Honorable Chiramba is not here, neither one from LPM, so we defer it to next Thursday, the 13th. Question number 67. They also it is put by Honorable Mutu of LPM to the Minister in Presidency. She's not here, neither one of the member of LPM. Question number 71. 71. Question number 71 is the same by Honorable Kodi of LPM to the Minister of Mines and Energy. She's also not here. Question 74 is by Honorable Hamata to the Minister of Urban and Rural Development. The Minister is not here. Question number 74 is by Honorable McHenry Benani to the Minister in the Presidency. She's also not here. But can we listen? Question number 76 by Honorable Dichart to the Deputy Prime Minister and Minister of Work and Transport. It's not here. And the Deputy Minister said she's not a minister, so it's waiting for. It will wait for him to be here. Question number 79. Question number 79 is by Honorable Ekanjo. Swapo Party to the Minister in Presidency. Is also the Minister is also not here. Yeah? Okay, please.
Thank you, Comrade Deputy Speaker. Honorable members, as I said last year, 2023, that there is a mouse and cat playing. I mentioned those words. A mouse and a cat playing around. I am saying this for the following reason, comrade, honorable members. I tabled these bills in
Can we wait on
these questions, because my questions.
Alias, just wait.
My questions.
No, your question, you put it to the Minister in Presidency.
Yeah, that's why I say I want to make a statement.
She's not here.
I want to make a statement on this.
Can you, it's not under which rule?
Yeah.
Can we wait for her to be here? I should think next Thursday she will
I've
be
been
here.
waiting for 2 years.
Sorry?
For 2 years, waiting for this to be answered. After 2 weeks.
No. It's beyond my control because I don't know the
That's why I
reason
said, let me
she's not
express
here.
myself. After 2 weeks, this parliament will be dissolved after 2 weeks. And then all these bills will, unanswered, will lapse. For 2 weeks, for 2 years, whenever these questions come, the minister is not there. For 2 years. Meaning, if I have to wait again after 2 weeks, then my term as a member of this parliament will expire on the 18th or 19th of this month, 2 weeks from now, after 35 years serving in this. When am I going to? Or is the new parliament again going to start again from the beginning? That's why I said it is a cat and mouse playing. I have been waiting for 2 years. Now it's going for 2 years. All the other bills, even the amendment to the Marriage Act and others, these were done last 2023. And bills that were introduced in this house last year toward the end is already assented to. And according, I'm going to read for this, according to this constitution, comrade, that's why I say I have to. Because after 2 weeks, we are not here. If I have to wait, next week, Thursday, the minister will not be here. Another week, Thursday, the minister will not be here. The third week, the parliament is dissolved. Why? That's why, according to this constitution, it says, accent to the bills. Assent to the bills, Article 56 of the Constitution, Article 56 of the 2014 amended constitutions, Article 56. I have to say this, otherwise after 2 weeks we are not here. Assent to bills, Articles 56, sub-article 1. Pardon? Every bill passed by Parliament in this Constitution, in order to acquire the status of an Act of Parliament, shall require the assent of the President to be signified by the signing of the bill and the publication of the Act in the Gazette. Sub-article 2. Where a bill is passed by a majority of 2/3 of all members of the National Assembly and has been confirmed by the National Council, the President shall be obliged to give his or her assent thereto. Sub-article 3. Where a bill is passed by a majority of the members of the National Assembly, but such majority consists of less than 2/3 of all members of the National Assembly, and has been confirmed by the National Council, but the President declines to assent to such bill, the President shall communicate such dissent to the Speaker. 4. If the President has declined to the assent to the bill under sub-article 3 thereof, the National Assembly may reconsider the bill. Okay, this is nothing, but these two bills has been passed by a majority of 2/3 of both houses of Parliament. And according to this Constitution, if the bill is passed by 2/3 of majority of both houses, the President has to assent to it. That is here in this Constitution. And also it said, if the President is not of the opinion to sign, he has to inform the Speaker. And then the Speaker has to inform this House. This is not done. But where a bill is passed by 2/3 majority of both houses, the president has just to sign it. That's why in my questions here, on the table there, I asked and said, the president, with the president, I mean any person who is a president. Let it be made clear. Because this constitution does not talk specific to an individual. It said any person who has to happen to be a president at that particular time. So if the president, there in the question I asked, the president has taken an oath, any president in any material time took an oath to protect the Constitution. So that's why I said for this, I view it is a deliberate. For 2 years almost, it cannot be. It must be made clear, comrade, honorable members, honorable comrade, in this Constitution. 1989, when this Constitution was drafted, the UN, the Western Five, provided Chapter 3 during the negotiations that the International Human Rights Convention must be included here. It was in the discussion. SWAPO, the Western Five, and the frontline states agreed to put this in the Constitution. So the Articles, Chapter 3, here in this Constitution is a photocopy of the International Human Rights Convention that was adopted in San Francisco or somewhere there by the UN in 1948. It is exactly the same. And in this, they talk of human right, the Chapter 3. That's why in all the chapters, the Chapter 3, subsector said, every person shall have the right to do ABC. Every person shall have the right to do ABC. But when it comes to family, to marriage, including in the International Human Rights Convention, it said men and women. The Chapter 3 of the International Human Rights Convention, this one is a copy. When they talk of, because some people say of sex, it says all the people shall be equal before the law, irrespective of their economic status, their religious, sex, and their belief. With sex there, it means men and women must be treated equally. It does not mean men must marry each other. No. It does not mean that way. It should be made clear. When we talk of sex here, it says all the people shall be equal before the law, irrespective of sex, irrespective of economic status, irrespective of race, color, language group, with sex. I am saying this because after 2 weeks, this piece will lapse. It will lapse. So let it be answered next week.
Yes.
Pardon? No. Pardon? It must be taken seriously. It's serious. Comrade, it's serious. The independence of this country did not come. We didn't spend our years in jail for nothing. The independence, there are people in the villages, up to date, they don't have arms, legs and whatever. Blood flows for more than 100 years. From the time of the Germans when they come here, and the Boers after came here, they followed, and all this, more than 100 years, comrade. Germany ruled this country from 1883 up to 1915. South Africa ruled this country from 1915 up to 12 o'clock, 24 hours, midnight, 1990 March. And in all those years, many people suffered. People disappeared. We cannot be described by Western countries and America to come and allow homosexuality here and make it a law. No, never. So I said, that's why I said, cat and mouse playing around. I can view it that it is deliberate. All the other laws were passed, but not this one. Why? Why? Parliament is the only platform I have to express about on this. That's the only platform I have. So I have to, because the bill was passed here by this House. Otherwise, the rules and procedure of the Parliament must change that if the President does not accede to the bills, what does the Parliament do? Must the Parliament pass it or how? By 2/3 in both houses. If a bill is passed by 2/3, the President has just to sign. No other way. I move my case. Thank you.
Yeah, there are only 3 minutes before we go for tea break. I put the next one is question number 81 by Honorable Chiramba, as well as 82 is the same Honorable. These two questions stood over because the person who put the question is not here. Environment and the same applies to question number 83 by Honorable Fries of PDM to the Minister of Environment and Forestry and Tourism. Both the Minister and the Deputy Minister are not here. Send over. They are not here. It's sent over to next Thursday. Question 84 is Honorable Van den Heervel of PDM to the Minister in Presidency. It's also not here. Stood over. Honorable Van den Heervel to the Minister of Education, Art and Culture is question number 85. Honorable Minister, can you say something before we go for tea break? Deputy Minister. You would like to put the question on behalf of... You would like to put the question?
Yes, Honorable Deputy Speaker, I put the question through.
Okay, thank you.
Okay, thank you. Honorable Speaker, I rise in this August House to respond to the question asked by Honorable Jennifer Van den Heervel of PDM in relation to the state of Owela Exhibition and Educational Center that has been shut down for the past 4 years and is in deplorable and filthy state. I would like to respond as follows. Honorable Deputy Speaker, honorable members, as it relates to the question on why the upkeep of this center has not been a priority for the ministry, I wish to inform the honorable members that the National Museum of Namibia, under the custodianship of Ministry of Education, Arts and Culture, is responsible for the maintenance of the Owela Museum and acknowledges full responsibility for its current state. At the onset, I want to inform the honorable members that the current structure which houses the Owela Museum is part of the complex inaugurated in 1958. That's why we find it in this state. And it must be stressed that since then, no major infrastructure renovation has been taken place. Therefore, the building is currently in dilapidated state with regard to its electrical and civil structures. The display center was closed in February 2020, pending renovation, and this translates into 4 years of closure. The decision to close the display center was informed by the wide range of factors, such as the infrastructural challenges in its civil structure, as well as its electrical system, which rendered the museum unsafe for human use and occupation. The other factors that may have contributed to this deterioration are the main two are, number one, the constraint of the budget. Limited financial resources have hindered maintenance, restoration, and modernization. The second one, number two, is the lack of specialized expertise. Sustaining the museum requires technical conservation skills, specialized staff, and resources for exhibition renewal and infrastructure rehabilitation, which remain limited. However, efforts are ongoing to secure funding and expertise to revitalize this important cultural institution. Honorable Speaker, Deputy Speaker, honorable members, in respect of the investment towards the maintaining and empowering national heritage and cultural programs, the Ministry, as part of Accelerated Infrastructure Development Plan, Owela and other museum sites, such as the Altefeste Museum Eka Independence Memorial Museum and the Camel Stable, are all lined up for prioritized for rehabilitation. With this, the ministry partnered, and as I say, because of the limited funds, we partnered with the Ministry of Works, Transport, and other partners, such as the Office of the First Lady, Her Excellency Madame Seski Bumba, in order to solicit funding complementing ministerial allocation to carry out the necessary renovation. Fencing of the display center start within, I think it started already last month, February. The contractors were already engaged and are expected to be on site as we are speaking. This is utmost importance as the unsecure fence of the museum facilities repugnant access to its premises, leading to illegal squatting by homeless people and ex-convicts. Also, the electrical renovation of the center will commence thereafter. The whole renovation process is expected to be completed within this year 2025 calendar year. As we are aware, honorable members, notwithstanding the fact that the ministry receives the bulk of the public funding, the highest allocation goes mostly to formal education, such that other units, including arts and culture, received limited budget, especially in the respect of capital investment, not as a deliberate move to deprive this program from funding, no, but as a way of limited funding we're experiencing. It is worth mentioning here that insufficient allocation to arts and culture and heritage programs is a great concern to the Ministry of Education, Arts and Culture. And thus, these programs are prioritized as one of the key levers of change project charter for the implementation of the 2022 National Conference Education Resolution. Rest assured, now that it is there in the charter, it will be attended to. We started actually already. I believe the above negate the perception of neglect. Honorable Deputy Speaker, it is only unfortunate, as I said above, that the ministry's budget often has to be stretched along its various units, with formal education taking up the biggest allocation. In order to bridge this gap in resource allocation, the ministry ventured into alternative avenues to secure funding through donors and public-private partnership to help address these challenges by providing access to educational resources, educational skills, and networks. For example, the Camel Stable has benefited from the public-private partnership with Dual Vision Production to CC. The basis of this agreement is to cooperate to transform the property into space of arts, culture, and heritage significance, which will be a one-stop shop for Namibians and international visitors. The Independence Memorial Museum continues to be maintained by the Ministry. Another partnership has been forged between the Ministry of Education, Arts and Culture, the Namibian Arts and the Craft Design Center to jointly manage the artifacts. This is done in order to sustainably promote and support the local cultural and creative sector by creating the cultural platform that enables cultural practitioners and entrepreneurs to make a sustainable living from their cultural and creative products and expressions. This in turn has the potential to positively impact the contribution of the cultural and creative sector to the gross domestic product of the country. Honorable Deputy Speaker, honorable members, I wish to pronounce to this august House that the Ministry of Education, Arts and Culture remains committed to addressing these challenges and is exploring solutions to restore and preserve this significant cultural institution and many others. On the question as to when can the nation expect the renovation to start at the Owela Exhibition and Education Center, as I said, it is pleased to note that the ministry has committed funds already towards the renovation of the Owela Display Center, with renovations earmarked to resume this, as I said already, started already in February. Although we cannot preempt the exact reopening date at this stage, we can confidently state that 2025 will not pass without officially opening of Owela Museum. In conclusion, Honorable Deputy Speaker, be rest assured that indeed the Ministry recognizes the importance of Owela Display Center to both tourists and the general public and will ensure its restoration meets the highest standard. We appreciate the patient and continuing interest in the preserving of our cultural heritage. Honorable Deputy Speaker, I so submit. Thank you.
With that, we break for tea and we come back 10 past 2. 10 past 4. 10 past 4. 10 minutes past 4.
I will not repeat the questions for expedience. So I rise, Honorable Deputy Speaker, I rise to address the questions raised by Honorable Elma Dinda regarding security for costs. The Honorable Member has expressed concerns that the requirement for parties in legal proceedings to provide security for costs, which is intended to ensure that potential legal expenses are covered, may sometimes be applied in a way that unfairly disadvantages financially weaker parties. She has also highlighted that this requirement could create a barrier that prevents individuals from pursuing or defending cases and ultimately from seeking justice. I have now looked at each one of those questions and wish to respond to each one of them as raised by the Honourable Member. In respect of question number 1, in the case of Hepute and others versus the Minister of Mines and Energy and another, a 2008 case, the Supreme Court reaffirmed the common law principle that as a general rule, insular plaintiffs or applicants, in other words, those residing within Namibia, are not required to provide security for costs. This principle is rooted in the idea that every citizen should have uninhibited access to the courts, ensuring that financial barriers do not impede the right to seek justice. Therefore, no, the requirement of security for costs, Honourable Dinda, in terms of Rule 62 of the Rules of the Magistrates' Court, does not create an unfair financial obstacle that prevents individuals or small businesses from seeking justice. Defendants may require certain categories of plaintiffs to provide security for the cost of the lawsuit. These categories include any plaintiff not resident in Namibia, an unrehabilitated insolvent, a company or someone with no real interest in the outcome of the case. Unless the plaintiff has obtained leave to sue as a pauper, in other words, a person without any financial resources, where security for cost is applied for, the court has a discretion. There must be an application before court. If such request to pay security for cost is not complied with within 7 days, the court may, on application, either stay the proceedings until such request is complied with or dismiss the action. The court has a discretion, and I think we have seen the court's discretion being applied in the electoral case just recently. In respect of number 2, the rules of the Magistrates' Courts and the Magistrates' Court Act 32 of 1944, as amended, are clear that even a pauper, in other words, a person who does not have the financial means, can sue with leave of the court. As a general rule, where the court orders security for cost, they must be paid. However, if the plaintiff is unable to pay, he must first apply to be exempted from paying security for cost and prosecute the matter as a deo litigant. But this does not exempt him or her from adverse cost. Therefore, this is not a tactic to silence strong legal claims. Number 3, there is always room to apply to the court for exemption from paying security for cost, and the court always has a discretion to grant or deny the application. It really depends on the circumstances of each case and also the individual that is applying for cost. Therefore, an order for security for cost does not unjustly deny a litigant their constitutional right to a fair trial unless a litigant did not apply to sue as a pauper. In respect of number 4, that will not be the case if you look at the question, as the case has not been ventilated. The purpose of security for cost is in the event of plaintiff succeeding with a claim. It serves as a guarantee that the legal cost be satisfied. This must not be confused with cost that follows the action. These costs serve as guarantee to the other party that in the event one loses the action, he would be able to cover the legal cost of the successful party. In respect of question number 5, the answer is no. It does not, as security is not mandatory in all civil suits. It only applies to the categories in Rule 62, but the court still has a discretion, as previously stated. The rule is open to plaintiffs, including those categorized in Rule 60, to apply for exemption, which the court may grant or decline. In respect of number 6, it really depends on the circumstances of each case. The magistrate can still exempt or order a party to pay his own cost. In respect of the last question, Honorable Dinda, the functions of the courts are really to interpret the laws. The issues of amending or introducing more flexible rules lies with this august House and also lies with policymakers and not the courts. But as a former chairperson of the Law Reform and Development Commission, I'm aware that there is a project on locus standi that was intended to broaden the scope of locus standi to include class actions and improve the system of people taking matters to court. And I commit to share your last question with the current chairperson of the Law Reform and Development Commission to resuscitate that particular project, and that may help a little bit with addressing your concerns around public interest litigation. Thank you very much.
Thank you. It's clear. Then we move to question number 89. It's by Honorable Dinda to the Minister of Defense and Veteran Affairs. Honorable Minister, I would like to put the question. Honorable Minister, question number, or Deputy Minister, question number 89. Yeah? Well, it was answered. Yeah, Honorable Minister, maybe to put the record clear, is it done already? Is it answered, or where are we?
We have answered this question here. Yes, just go to the record, because I was here and I answered everything.
Yeah.
So if there is no record, of my answer, because I had it.
Yeah.
I will then, if there is no record,
let me ask Nehwaya. Was it answered?
We really remember.
It was not. They are not aware. It was not. Maybe it was not answered.
Check.
Is he here? So, Deputy Speaker, if the record says I have not answered, I can repeat it.
Okay.
Because it is here.
We'll benefit it.
Thank you.
Okay.
Honorable, I'm sorry if I did not answer. I thought I did. but I...
Yeah, okay.
Honorable Speaker, honorable members, I would like to start by wishing you all, it was quite a while ago, a happy and productive 2025. Despite us having started this year on a I remember I answered that. Following the passing of our first president and founder of the Namibian state, His Excellency Dr. Sam Safishuna Nujoma, it is my wish that as we continue the journey of governing this country, without him in our midst, as an elderly statesman, we shall do so as united people, working towards propelling this nation to greater heights. I rise to respond to the questions by Honorable Dinda on the war on the Democratic Republic of the Congo. Thank you, Honorable Dinda, for showing interest on the security situation of a fellow SADC member state. An injury to one of us is an injury to all of us. Today is the DRC under siege. Tomorrow it could be us, and we too will rely on support from other states. Honorable members, from my understanding of your question, no, this was honorable member. From my understanding of your questions, your central tenet seems to be that it will be good for Namibia to show support through the deployment of troops to the DRC. Supporting a fellow member state under the umbrella of SADC in this or any other case does not necessarily have to be militarily. Because we have not or are not sending troops to the DRC, it does not mean we have not we have removed ourselves from fulfilling our obligations of contributing to the achievement of peace in our region under the leadership of SADC. And as such, do not see how our already existing good fraternal relations will be jeopardized, that is with the DRC. We remain steadfast in our resolve of playing our part in ensuring that peace is restored in the eastern part of the DRC. Hence, we have been and continue to be involved in the United Nations peacekeeping missions in conflict-ridden countries around the world. With regard to our support to the SADC mission in the DRC, we had pledged to provide financial and political support, which we have done without fail, despite the meager resources at our disposal. As you are aware, in the late 1990s, along with Angola and Zimbabwe, we were deployed in the DRC on a peacemaking mission, which was successfully carried out, resulting in the deployment of the UN peacekeeping forces under MONUSCO. Honorable Speaker, honorable members, despite the presence of foreign troops in the DRC at the moment, that conflict is internal and requires a political solution. This has been our belief, and it was one of the resolutions of SADC summit held in Zimbabwe on the 31st of January 2025. The same resolution was echoed by the East African Community and the SADC joint summit in Tanzania on the 8th of February 2025. The two regional bodies have put measures in place to ensure that peace in the eastern part of the DRC is realized. We are fully behind the two regional bodies' efforts, and we shall continue to make our contributions, promote and encourage the attainment of peace through dialogue. In conclusion, Honorable Speaker, honorable members, experience has taught us that people go to war as the last resort when their political expectations are not met. However, as you may be aware, war is a very destructive and expensive undertaking which should be avoided by all means. Any opportunity for peace that avails itself must be used. Thus, it is our firm belief that the DRC conflict can be resolved through dialogue, and we shall continue to support efforts in that direction. Thank you, Honorable Speaker, for having given me the opportunity to respond to the Honorable Member from the PDM. I hope I have clarified the Government of the Republic of Namibia's position on this matter, and I thank you.
Request from the Minister of Urban Rural Development to question number 74. He is now here. It's a question put by Honorable Hamata of PDM. Who would like to put that on behalf of Hamata?
And delegated to put through all questions from PDM, please.
Okay. Honorable Minister.
Thank you very much, Honorable Deputy Speaker. I rise to respond to questions raised by Honorable Mata. Honorable Deputy Speaker, honorable members, on the 10th day of September 2024, Honorable Hamata gave a notice that on Thursday, the 19th September 2024, he would ask me questions which I will attempt to in a minute. Honorable members, before I attend to the questions of the honorable member, I wish to draw the attention of this august House, Honorable Speaker, that we are lawmakers, and the assumption out there is that we should be the first citizens to understand the law. First, the honorable member is asking questions that are of an operational nature and, in my view, negates the core and principles that are set out in the Article 94B of the Namibian Constitution. The honorable member should also understand that when I familiarize myself with the entire Electoral Act number 5 of 2014 as amended, I couldn't locate any provision assigning me with any power or duty as being a minister responsible for Electoral Commission oversight, except Section 209, which is entitled Short Title and Commencement. I quote the subsections for honorable members' benefit. This act is called the Electoral Act 2014 and comes into operation on a date determined by the minister responsible for regional and local government by notice in the Gazette. Different dates may be determined under subsection 1 in respect of different provisions of this Act. Unquote. My reading of the above captioned legislative provisions is that it is clear and ambiguous in that my power, insofar as electoral matters are concerned, is limited to the lawmaking process and nothing else. Having said the above, Honorable Deputy Speaker, honorable members, I reached out to the Electoral Commission of Namibia, an independent Namibian electoral management body. I should gladly say that ECN was willing to provide me with information enabling me to prepare these responses to the questions of the honorable member. Honorable Deputy Speaker, honorable members, I shall now proceed to respond to the honorable member's questions. I'm not going to repeat the questions. Question 1, the answer is the ECN's mandate is provided for in the Constitution of Namibia and supplemented by the Act of Parliament, being the Electoral Act number 5 of 2014, is the exclusive body to direct, supervise, management body. I should gladly say that ECN was willing to provide me with information enabling me to prepare these responses to the questions of the honorable member. Honorable Deputy Speaker, honorable members, let me now touch on questions as it is now. The ECN, the ECN's mandate is provided for in Constitution of the Republic of Namibia and supplemented by the Act of Parliament, being Electoral Act, as exclusive body to direct, supervise, I'm sorry it's repeating itself here, manage and control the conduct of elections, and the referenda is solely subjected to the Constitution and law. The Act of Parliament, which is the Electoral Act, defines its powers, functions, and duties of the Commission. Among the powers, functions, and duties entrusted to the Commission is to establish, register, and deregister political parties and organizations as provided for in Chapter 4 of the Electoral Act. Upon the implementation of the Electoral Act in 2014, regulations were made in terms of this legislation, specifically on asset declarations and financing disclosure. In 2019, the Commission began raising awareness in respect of the political parties' compliance obligations. The Commission deemed it prudent to convene engagement with political parties and organizations with the view of explaining key provisions and outlined the consequences of non-compliance. The provisions in question are Section 140, which provides for the keeping of records and conducting of an audit of registered political parties, and Section 158, which requires political parties represented in Parliament to account for the funds allocated to them. The engagements refer to date back 2017 and continued in 2019 when the Commission published regulations simplifying the application thereof. Section 139, which provides for the declaration of assets and liabilities of the registered political parties and organization association. Section 141, which provides for the disclosure of foreign and domestic financing of political parties, organizations, or other persons. A careful reading of these provisions reveals that these are peremptory provisions demanding compliance from and by all registered political parties and organizations. Despite the Commission's efforts of engagement with political parties, as enumerated above, the Commission's request for submission by political parties and organizations and subsequent reminders remained unheeded. The Commission continued with its efforts from November 2020, and in November 2021, the Commission addressed correspondence to all authorized representatives of registered political parties directing a compliance deadline of 31st March 2022. Following a poor compliance response by the political parties, the Commission resolved to conduct a workshop which was held in September 2022. The workshop was aimed at reinforcing the understanding of political parties and organizations on the importance of compliance. Following this workshop, the Commission extended the compliance deadline to 31st August 2022. However, a number of political parties missed the said deadline. The Commission subsequently resolved to invoke Section 152, which provides for the cancellation of the registered political parties or registered organizations. In compliance with Section 152F, the Commission's resolved to have same preceded by one-on-one engagements with all affected political parties. To afford the political parties a further opportunity to make representations on the reasons underpinning their non-compliance. These individual engagements were held in June 2023. Following these engagements, the Commission resolved to grant a 5-month extension and allow political parties to comply by 30 of November 2023. Following this, the Commission observed substantial compliance by some political parties, while others persisted with non-compliance. The above sequence of events is evident from the higher court judgment, which records the facts as presented in court. It is important to note that the court never excused the political parties in question from the peremptory compliance obligations as dictated by the Act. The court made it patently clear that the said political parties were in a patent violation of the law with the caveat that when the Commission took the final decision of cancellation, the parties must have been invited in to apprise the Commission with reasons as to why such a decision should not to be made final. The Court, in this regard, in my view, acted as an arbiter and dutifully executed its checks and balances role insofar as the process followed by the Commission is concerned. The Court, as an independent organ, acted within its mandate to review the decision which was challenged. This being the case, should not be construed to undermine the Commission's integrity, capability to execute its constitutional mandate. The next question, yes, I'm not going to repeat. I have already detailed the process followed by the Commission before it arrived at the decision taken on the 13th June 2024 to deregister the non-compliant political parties that were, in its view, in violation of the Electoral Act. It suffices to say the Commission, in all its dealings, has been and continues to deliver its mandate as provided for in the law. The action taken by the Commission at the time were those as prescribed by the Electoral Act. The Commission, no doubt, will remain ready to deliver fair, credible, and transparent elections in Namibia. The third question, I'm not going to read it, but I'll just go to the answer. Honorable Member, I have already referred to you to the legal instruments bestowing the Commission with its mandate. The legal instruments clearly define the constitutional mandate of the Commission, its powers, functions, and duties, and it is my conviction that the Commission is alive to upholding such an undertaking. The Minister has no power to oversight functions over the Commission's operations, and even if I could have such power or functions, my action would have been informed by rule of law and not to go with the Honourable Member's perception. The Court's judgment clearly set out the relevant legal principle applicable to this matter. Question 4, the answer is Namibia is a constitutional democracy, and the values enshrined then apply and regulate the conduct of all our institutions, including the ECN. The ECN has been delivering fair, credible, and transparent elections in this country since 1992. This act of higher performance and adherence to guiding legal principles are vital to the Commission. The Commission has always assured the general public, and in particular the stakeholders in the electoral matters, that transparency is the key and nothing under the sun will ever change this position. 5, the answer is, Honourable Member, the Commission, by deregistering non-compliant political parties, was simply enforcing the law against the violators of the law, as found by the Court, by being serial non-compliers with the provisions of the Act. To be fair, let me refer you to the relevant portion of the judgment, specifically paragraph 103
of the judgment. While I have no qualms that the respondent, the Commission, was correct in its opinion that the applicant had been a serial non-complier with the provisions of the Act, such that it could be regarded as having persisted as having in the contravention of the Act. I'm not satisfied that the applicant was afforded a hearing regarding the decision to cancel its registration as a political party. So this was the court judgment. Deducting from the above, it is apparent that the Commission has done everything within its power to enforce the law by deregistering the violators of the law. I therefore have no doubt in my mind that the conduct of the Commission in deregistering these non-compliant political parties, including the one that you become a spokesperson of, could have been avoided if all political parties were complying. Perhaps the big question is for the political parties to also do an introspection as to why there is non-compliance. Public trust should not be viewed as one-sided because it also includes the use and accountability of public funds. I would rather invite you, Honourable Member, to familiarize yourself with our electoral law and apprise yourself of the dynamics of our electoral process. There is no room for manipulation in our laws, and there shall never be. In conclusion, therefore, I wish to reiterate that there is no lack of competency of the Commission, and this has been demonstrated by recent judgment delivered by our Supreme Court in the presidential challenge by Itura and two others versus the President of the Republic of Namibia and 32 others delivered on the 28th February 2025, case number 82/2024. I so submit.
Thank you. Yeah, we proceed to question number 9090 by Honorable Hamata to the Minister of Agriculture, Water and Land Reform.
Yes, I'm putting the question through.
Okay. Honorable Minister, question number 9090.
Honourable Deputy Speaker, honourable members, I rise to respond to the question posed by Honourable Lucas Hamata of the Popular Democratic Movement, PDM, on the 5th January this year. Honourable Speaker, as a prelude, one must recognise the right of a member to ask questions and the obligation of the member of the executive to answer them to the best of their ability. I fully subscribe to that because I am convinced that such checks and balances are important to ensure accountability and transparency. In the case of this question, however, I have had a serious look at the prelude of the following question posed, and my observations are the following. Honourable Hamata relied on opinions circulating on the social media platforms and not on factual evidence, which he could have easily obtained by reading the Act or contacting the Ministry. In his prelude to the question, he said, and I need to quote it, I quote, "However, recent revelations indicate that a serving judge, Judge Shafimana Gutele, was granted land tax exemption
while presiding over a case in which the first defendant was Minister Khalid Redwine himself. This raises serious concerns about whether the exemption process is being fairly and lawfully administered, or whether it is being used to unduly benefit individuals in positions of influence. Honourable Deputy, the question would have been okay, was it not for the allegation that unfair and unlawful behaviour of both the judge and the minister is brought into this House without a shred of evidence, as I will show in my following answer. It is unfortunate, and I cannot other than conclude that Honourable Hamata deliberately tried to undermine and discredit the judiciary and the executive arms of the Republic. He did so in the National Assembly to hide behind the immunity he enjoys in the House. Such behaviour is nothing but abuse of the privilege honourable members enjoy. Honourable Speaker, every member in the National Assembly, the principal law-making institution of the Republic, took an oath. And the oath said, amongst others, to uphold and defend the Constitution and laws of the Republic of Namibia to the best of my ability. Honourable Hamata took that oath. This deliberate and false discrediting a Supreme Court judge, implicitly the judiciary, and a cabinet minister, a member of the executive, of collusion for own gain, is not in line with the member's obligation as per the oath. It harms the good reputation of the state institutions, and in fact, it harms the integrity of both individuals. Honourable Speaker, I shall now proceed to put the correct factual record to the Namibian nation. As background, the Agricultural Commercial Land Reform Act, Act 6 of 1995, as amended, empowers the Minister of Agriculture, Water and Land Reform to impose and implement land taxes on all agricultural commercial land in Namibia. This legal framework remains the foundation of all land taxation measures related to agricultural land. That's commercial agricultural land. Section 76B, 1 of the Agricultural Land Reform Act provides that the Minister may, on application made to him or her by an owner of an agricultural land, exempt by notice in the Gazette for such period as may be specified in that notice from land tax imposed pursuant to Section 76, which A, in turn stipulates that any agricultural land of such owner, but only if he or she is a person belonging to the category of persons contemplated in Article 23 of the Namibian Constitution. B, any agricultural land that is primarily used for activities of a church, mission, hospital, school, or hostel, provided that such activities shall not be for profit gain. 2, any state-aided institution or any charitable institution as defined in section of the Value Added Tax Act 10 of 2000. 2, an application referred to in subsection 1 shall be in such form as the Minister may determine and shall specify the agricultural land to which it relates. And 3, the Minister may revoke any exemption granted under subsection 1 if reasons for granting such exemption ceases to exist, but shall do so only after having afforded the owner concerned an opportunity to be heard. Now, honourable members, that was the information that the honourable member should have gained when he read the Act, but he didn't. Now, to question 1, which asks, under what legal provisions or constitutional powers does your ministry grant tax exemptions and what criteria must be applicable, must be applicant met to qualify? I have given you the legal status, which he could have gotten himself by reading the Act. But I will respond further that the Minister of Agriculture, Water and Land Reform grants land tax exemptions under provisions contemplated, as I said, Article 23(2) of the Namibian Constitution, based on the formal application process, which is subject to review and revocation should the conditions for exemption cease to exist. This ensures that the exemptions are applied fairly and transparently, in alignment with Namibian constitutional and legislative mandates. The constitutional provision found expression in Section 26 or 76B(1)(a) of the Agricultural Land Reform Act, Act 2 of 2001, where application of land tax exemption is provided for. Since the inception of the land tax program in 2004-05 financial year, the Ministry has consistently applied these legal provisions to support formerly disadvantaged groups while maintaining a fair taxation system. Contrary to claims that the land tax is arbitrarily applied or that exemptions are granted without a legal basis, Section 76B of the Agricultural Commercial Land Act explicitly provides the specific qualifying criteria and circumstances under which Namibians qualify to apply for land tax exemption. These include person falling into categories of Article 23(2) of the Constitution, which reads, "Nothing contained in Article 10 of the Constitution hereof shall prevent Parliament from enacting legislation providing directly or indirectly for the advancements of persons within Namibia who have been socially, economically, or educationally disadvantaged by past discriminatory laws or practices, or for the implementation of policies and programs aimed at redressing social, economic, and educational imbalances in the Namibian society arising from the past discriminatory laws or practices, or for achieving balanced structure in the public service, the defence force, the police force, and the correctional services." The relevant sections of the Agricultural Land Reform Act 6 I have addressed. And I can confirm that the Honourable Judge surely qualifies squarely as a disadvantaged person and was legitimately applying. Question 2. On what basis was Judge Shapishina Iwatele granted an exemption from paying land tax? And does he fall under any legal categories outlined in the Act? As already indicated in my response to question 1 above, the judge applied and was granted land tax exemption on the basis of the fact that he squarely falls within the categories of former disadvantaged Namibians, as articulated under Article 23 of the Constitution of the Republic of Namibia, namely, and I do not want to repeat, individuals who have been socially, economically, and educationally disadvantaged due to past discriminatory laws and practices. Further, it must be stated that the process of applying and granting land tax exemptions is initiated prior to the granting of the exemption. In this particular instance, on the 29th of April 2022, the Ministry issued a public notice in the Republican, the Namibian, the Sun, and the Allgemeine Zeitung, informing all farm owners about the land tax assessment for the financial years 2016-17, 17-18, 18-19, 19-20, and 2021. The due date for these payments was the 31st March 2024. In the same public notice, farm owners who met the criteria of exemption, as alluded to early, were urged to apply for the March before 31st March 2024. The Ministry processed and gazetted all those farm owners who applied and met the exemption criteria as outlined above on the 1st August 2024, as per the provisions of the Act. Mr. Sri, did Judge Waitela apply for the exemption, or was it granted at the Minister's discretion? If so, what justification was provided in this application? Honourable Speaker, to give context to this question, I would like to offer further factual information and bring clarity by indicating that the Deeds Registry records confirm that in 2021, Mr. Shafimana Fikameni Emmanuel Waitele was the registered owner of the following two farms, being farm number 933, measuring 4,867.0781 hectares, situated in the registration division L of the Omaheke region, and portion 1 of the farm Wolseley, number 938, measuring 1,732 hectares, 0908 hectare, situated in the registration division L in the Omaheke region. Thereafter, portion 1 of the farm Wolseley, number 938, in the registration division L was sold and transferred to a Mr. Nikki Shimweshili Shikamekeleni on the 28th July 2021. Our tax records indicate that during the financial year of 2018-19 and 19-20-21, Mr. Shafimana Fikameni Emmanuel Waitele applied for land tax exemption and was granted in respect of farm number 933, measuring 4,867.0781 hectare, situated in the registration division L in the Omaheke region. It should be also noted that in the financial year of 2019 and 2020, with the approval of yourselves in the National Assembly, it was agreed to impose a zero tax rating for all agricultural commercial farms to ameliorate the negative impacts due to COVID-19. Mr. Waitele's applications were made pursuant to Section 26B of the Agricultural Land Reform Act, which stipulates that exemption may be granted to the person within Namibia who have socially, economically, and educationally disadvantaged by past discriminatory laws or practices, including women in Namibia, having traditionally suffered special discrimination as contemplated by Articles 23(2) and 3 in the Namibian Constitution. Furthermore, during the financial years 2013-14, the Ministry's land tax records indicates that as per law, Mr. Shafimana Fikameni Emmanuel Waitele applied for land tax exemption on this particular farm and it was granted. However, from the following financial years, that is 14-15, 15-16, 16-17, 17-18, 18-19, 20-21, and 21-22, our land tax records indicates that Mr. Shafimana Fikameni Emmanuel Waitele paid land tax in full, and the Ministry issued him with a land tax clearance certificate on the 21st July 2021. Contrary to what has been implied in this question, this factually indicates that the individual in question never exercised his right to apply for agricultural land tax as provided by the law for those years. Question 4. How many individuals have been granted land tax exemptions in the last 5 years, and what percentage of them were formerly disadvantaged persons as defined by law? Honourable Speaker, our land tax records indicate that a total of 2,272 formerly disadvantaged Namibians, as contemplated under Article 23(2) and 3 of the Namibian Constitution, applied for land tax and were granted exemption in 4 financial years, namely the 2016-17, 17-18, 18-19, and 2021 financial years. Respectively, in the 16-17, there were 568. In 17-18, there were 569. 569 in 2018 and 19, and 566 in 2021. However, it should be noted that during the financial year 2019 and 2020, we exempted or rated 0 the land tax because of COVID. And that was done with the approval of the National Assembly. Question 5. Does the Ministry have a transparent process in place for granting exemptions? And is there an independent review mechanism to prevent potential abuse in this discretion, of this discretion? Honourable Deputy Speaker, the administration of land tax is governed by a very strict legal framework that is supported by rigorous process and procedures laid out in Section 76B1A of the Agricultural Commercial Land Reform Second Amendment Act of 2001. There is no room for discretion in the granting of exemptions, as the Ministry has established a transparent process that includes clear criteria for eligibility and the submission of detailed documentation and the issuance of public notices of land tax assessments and exemptions in the print media and the Namibian Government Gazette. So if there's any query, the public has all the time and information available to query it because it is published in the local media and in the Gazette. Further, honourable members, the Ministry of Agriculture, Water and Land Reform grants exemptions based on a formal application process, which is subject to review and revocation should the conditions for exemption cease to exist. This ensures that exemptions are applied fairly and transparently, in alignment with Namibia's constitutional and legislative mandates. Since the inception of the land tax in 2004 and 5 financial year, the Ministry has consistently applied these legal provisions to support disadvantaged groups while maintaining a fair taxation system to farmers that are not exempted. For the land tax exemption application to be considered, the following documents are required to be submitted. A fully completed application form, which is obtainable from the Land Tax Division. Secondly, a land tax assessment for the financial year exemption is applied for. C, an identification document. Fourth, a power of attorney that is applicable when the applicant is made on behalf of the farm owner. And E, an executionership letter in the case of the state. Question 6. What measures will the Ministry put in place to ensure that exemptions are granted fairly and do not raise concerns of undue influence and preferential treatment? Honourable members, as indicated earlier, the instances of criteria under which the land tax exemptions are granted are provided in the constitutional provision of Article 23 and in the legal provisions of the Commercial Agricultural Land Reform Act 76B, as amended in 2001. The Ministry of Agriculture, Water and Land Reform has and will continue to be guided by these legal policy frameworks in the administration of the fair and transparent agricultural land tax implementation. Claims in the social media and by certain individuals suggesting otherwise are incorrect, untrue, false, whatever word you want to use, and misrepresent the intent of the application of the law. It is important to reiterate the intention of the Constitution and the law is to support formerly disadvantaged persons. And that is what we are doing consequently. Question 7. Does the Minister acknowledge that granting of tax exemptions to a judge presiding over a case involving the government creates a serious perception of a bias and undermines public trust in the fairness of judicial and ministerial decisions? Response: no, I do not acknowledge that. On the contrary, it is clear that the Ministry has a duty to grant land tax exemptions to any applicant who is Namibian, who qualifies and meets the criteria provided in terms of Article 23(2) of the Namibian Constitution and Section 76(1)(a) of the Agricultural Commercial Land Reform Act as amended in 2001. Despite any social, economic and political consideration of any individual. These provisions do not empower the Minister to distinguish between people in high position and in low positions, or whatever socio-economic status they have. So we don't do that. The lack of a factual base that is imbued in this notice of question, coupled with the sensational claims made in the print and social media in respect of the role of the Minister of Agriculture, Water and Land Reform in the administration of the land tax exemptions, are therefore very misleading and meant to incite negative public perception to the individual concerned in the Ministry and in general. It is cheap politicking at its worst. Honourable Speaker, I would like the House to take note that the Honourable Member, that is Honourable Hamata's questions, are factually incorrect and highly misleading and meant to tarnish the image of the individuals concerned. It is wrong for the said Member of Parliament, through purported notice of question, to propagate falsehood and serve to misinform the House and the Namibian people. I hope this response brings the factual clarity that was lacking on the matter. But I also hope, Honourable Deputy Speaker, that members are reprimanded if they do spread rumours of corruption or unlawfulness. It must be evidence-based. Just to say it here and hide behind your immunity is not what is expected from a member of high integrity in this House. And it happens every now and then that allegations of corruption are made without any evidence. So with that, I rest my case. Thank you.
Yeah, thank you. I wish you could be here to listen. Yeah. That said, we move to question number 91 by Honorable Kamati of PDM to the Minister of Home Affairs, Immigration, Safety and Security. Both the Minister and the Deputy, and they're not here. We can move to question number 92, pardon, by Honorable Mike Venani of PDM to the Minister of Agriculture, Water and Land Reform. Would you like to put the question? Would you like to put the question, Honorable?
Thank you.
Yes, Honorable Deputy Speaker, may I ask a question? Thank you.
Yeah, Honorable Minister, question number 92. 92.
Thank you, Honourable Deputy Speaker, and thank you, Honourable Denani, for the question. The question concerns the outbreak of lumpy skin disease in the country, and there are 4 follow-up questions that asks as follows. Why is there a delay in providing vaccines to the veterinary offices? The answer to that is it's very unfortunate that there was this delay, but unfortunately Namibia has no own capacity to produce vaccines. We are now looking into that matter. We had, as soon as the outbreak was notified, we requested the South African supplier to supply us with vaccines, and that was not immediately possible. There was a delay, and that is why the slowness of the response was a very unfortunate consequence. Secondly, will the government provide free subsidized vaccines to all affected farmers? Lumpy skin disease is not one of the 5 diseases that are becoming the responsibility of government, meaning that we supply free vaccines. Lumpy skin disease vaccination is the principal responsibility of the individual farmer, but we do, in communal lands and for subsistence farmers, provide vaccines for free, and we have done that in this case too. We have, in all our vaccination campaigns that followed, once we had the vaccine, vaccinated all cattle for free. All auctions in the areas have been cancelled as a result of this outbreak. Will the government introduce any emergency relief programs for the affected livestock farmers in the areas? Well, as the disease is a very contagious disease, it's actually an insect-transmitted disease. We try to localize and limit the further spread by cordoning that area off and not allow a movement. But once we are vaccinated, and there are now new outbreaks or incidences, we open up again. So there is no specific relief other than vaccination for free and informing farmers how the disease is spreading. But otherwise than that, no specific programs for now. And fourthly, what long-term strategies are being developed to prevent future outbreaks of lumpy skin disease? Well, lumpy skin disease is unfortunately on the increase. It has been becoming more frequent over years, and it is always coming at the beginning of the rainy season, and it holds through the rainy season, and then it dies off. The reason for that is that it is transmitted by mosquitoes that breed, like all mosquitoes, in water. So the moist seasons bring up a breeding peak of mosquitoes and then a spread of the disease. Now, we as I've indicated earlier, do 2 things. We first aim to build our own vaccination production ability, so that we have, for all the frequent diseases, and especially the 5 diseases, always vaccines available at a good time. Now, lumpy skin disease is a serious disease. We want to include that not in the diseases that are the responsibility of the state, but we want to improve our ability to have vaccines available immediately. And secondly, we entered into an agreement with the South African suppliers that we have exclusive access when we have an outbreak, and hopefully they have a small or a big reserve of vaccines that they can make available. But these vaccines do not last forever. They have a shelf life, which is not very long. So it is a tricky thing to balance out your purchasing of vaccines and the outbreak of diseases. You don't know how many and where. And that is what we have to answer in this case. I hope I was clear. Thank you very much.
Thank you. Any follow-up?
Thank you very much, Honorable Deputy Speaker, honorable members. Being myself also beef producer in the country, I'm very worried. Your monitoring system between your office and the veterinary under your ministry is very slow. And after you discover in your ministry that in communal land, those portions I mentioned is lack of inject their cattle for that disease. What is your action between your ministry and the farmers? The agency of this, to me, is a very fundamental, because being a farmer myself, or we here, we are living under that spotlight. How serious is your ministry on that issue, I think?
Well, Honourable Deputy Speaker, if you are a farmer and you farm with cattle, you are the owner of your livestock, and there are certain responsibilities that rest with you to look after your cattle. It includes vaccination. Where the state comes in, we can, through our extension services, inform farmers on vaccination schedules, when to vaccinate and where to get the vaccination if it is not available at our offices. And that is what we are doing. We are extending free vaccination campaigns and the supply of free vaccines in, as I said, in the communal areas where we know that the farmers are having very limited financial ability to procure these expensive medicines, but to have it, to as the state, take over the farming operation of an individual, we do not believe is the right way to do. The farmer is the farmer. The farmer is the owner of his livestock and his produce, and there is the main responsibility to look after your herd, whether it is large or small stock, remains with the farmer. We will help you where we can. Thank you.
Okay. Probably the last question before we go is 93. We cannot answer it. The minister and deputy minister are not here. We go for question number 94 by Honorable Chirare of PDM to the Minister of Justice. Would you like to put the question?
Honorable Deputy Speaker, I'll put the question through.
Honorable Minister of Justice.
Thank you, Honorable Deputy Speaker, Honorable Member. From the onset, I must indicate, unless being a party to the proceedings as a respondent, the Minister of Justice is not responsible for the execution of judgments generally. And although the Minister of Justice is not directly liable to answer this question, I deemed it necessary to very briefly respond to concerns of the Honourable Member as follows. Number one, should any party who has been ordered by court not adhere to or implement the order of a competent court, the aggrieved party may approach that same court for an order of contempt of court. Contempt of court includes, among others, the willful or negligent disobeying of a court order which attracts a criminal sanction. This is obviously once the judgment creditor has established who the judgment debtor is, and we don't wish to venture into who is liable for the damages suffered by the Honourable Member following the Supreme Court decision. It is our unsolicited advice that the Honourable Member may wish to approach their legal practitioner of record at the time to follow up on compliance with the order, to provide advice on what steps to take next, and to bring the relevant proceedings. In the case of Bakile and another, a 2024 High Court Main Division case, the court held, and I quote, "Unlawful and intentional disobedience of a court order is a crime that violates the dignity, repute, and authority of the court, which the rule of law, a founding value of the Constitution of the Republic of Namibia, requires to be maintained. I therefore conclude that the Honourable Member must return to the same court that granted the order and make out a case for contempt of court against the disobeying parties, who they may be, and seek relief in that court. We are therefore regrettably not able to provide and or deal with any of the other issues that the Honourable Member has raised in her question. Thank you.
I think that's a good advice. Any comment?
Thank you, Honourable Deputy Speaker, Honourable Minister. Thank you for the guidance. I shall duly follow suit. Thank you again for the audience. Thank you.
There's 5 minutes. I hope for this long question. Yeah, there is 5 minutes. It should be the last question, number 95. We would like to put the question, Honourable Muchila. Would you like to put the question or not?
Deputy.
No.
Deputy Speaker, I do.
Yes, listen to the presiding officer. Look at the presiding. Ignore the other people. Honourable Minister of Agriculture. Honourable Minister, I would like to try their question, but you can always summarize. 11 of them.
Thank you, Honourable Deputy Speaker. Thank you, Honourable Mochila, for the question. I will try to respond as quickly as I can, but it is a long question. So I will go as fast as I can. But before I provide my response to the question, I would like to give a brief background to the administration of communal land. The questions regard agricultural projects in communal land. Communal land is a state resource. Article 100 of the sovereign ownership of natural resources of the Constitution of the Republic of Namibia states that land, water and natural resources below and above the surface of the land and in the continental shelf and within the territorial waters and the executive economic zone of Namibia shall belong to the state, if they are not otherwise lawfully owned. So communal land is state land, belongs to the state. The above article is also contemplated in Section 17 of the Communal Land Reform Act, number 5 of 2002, as amended, and it states that all communal land vests in the state in trust for the benefit of the traditional communities residing in those areas and for the purpose of promoting economic and social development of the Namibian people, particularly the landless and those with insufficient access to land. The above legal framework gives a clear indication that communal land cannot be owned by anyone. People with land rights in communal areas only have user rights, with the state being the owner of the land. Therefore, communal land sales are prohibited in whatever form. Traditional authorities are mandated in terms of the legal framework to administer communal land and keep it in custody on behalf of the state. Traditional authorities have a custodial function, but they are not the owners. The Ministry of Agriculture, Water and Land Reform is aware that there are some elements of illegal sales of communal land. This becomes evident by the numerous land-related disputes lodged with the ministry. There is also illegal real estate promoting illegal sales of communal land in contravention with the Constitution of the Republic and the Communal Land Reform Act of 2002. These practices have led to many disputes emanating from illegal sales of communal land, illegal fencing of communal land, illegal occupation of communal land. In an effort to curtail the process of illegal sales of communal land, the Ministry of Agriculture, Water and Land Reform has conducted an outreach program by providing information to the public on procedures to be followed in order to acquire communal land rights. Furthermore, we have also informed the public on the status of communal land and the fact that it is not for sale, because all landholders have user rights only and no freehold rights. We therefore would like to discourage everyone with an idea of selling communal land, including potential investors who are illegally buying communal land or paying for whatever usage they have on the communal land, to stop forthwith and engage the concerned communal land boards for guidance on how to be allocated land rights procedurally. The Ministry of Agriculture, Water and Land Reform will not be responsible for any loss of any resources by any parties as a result of them illegally having occupied or transacted on the sale of communal land. Let me now attend to the question posed by Honourable Muchila. Question 1. Why has the Ministry not taken decisive action to establish large-scale agricultural schemes in these areas, despite the availability of fertile land and water? Honourable Deputy Speaker, it is true that the Ministry is yet to develop the offered pieces of land due to the 2020 moratorium by Treasury that halted most of all projects of a developmental nature amid world economic downturn and prevailing droughts that have affected governments worldwide. However, efforts are underway to have the land registered and designated as agricultural land, vis-à-vis communal land. Once designated as agricultural land, the second phase is to make budgetary allocations for the development of these areas or to invite participation by local partners and private sector partners in these areas to initiate development of agricultural projects in the line of green schemes and the green scheme policy. In addition, development of bulk infrastructure on brownfields into green schemes is capital intensive and costly. Over a couple of years, the Namibian economy has been experiencing economic headwinds which negatively affected the national budget. Government had a serious challenge in balancing the appropriation of limited budget resources to pressing and competing needs. This, together with other factors such as recurrent droughts, contributed to a slowdown in bulk infrastructure development for brownfield agricultural projects in all areas. The answers of questions 2 and 6 are combined, and I hope you are okay with it. Namibia continues to rely heavily on food imports, which places the country in a vulnerable position regarding food security. With the Zambezi region's capacity to contribute significantly to national food production, why has the Ministry not prioritized agricultural development in the region? How does the Ministry justify Namibia's continued reliance on food imports when we have resources to produce our own food? And question 6 is Namibia's National Development Plan and Vision 2030 both emphasize the importance of agricultural growth, food security, and economic diversification. How does the Minister justify the continued neglect of the Zambezi region? Honourable Speaker, let me first say that the Ministry of Agriculture, Water and Land Reform is responsible for the whole country. not only for the Zambezi region. So to dissect and separate the Zambezi region from other regions where there's also potential, where there's also economic need, is probably not the right thing to do. If the honourable member wants to have region-specific questions, I think there is the regional council and the regional authorities in a region which needs to be approached instead of central government. We at central government cover all. It is not to say that you are illegitimate in your question, but I just want to make sure that you understand that as government and our government public resources, the budget, is applicable and available to all, not only Zambezi.
He did ask the question concerning his constituency, the need of his constituency.
That is fine, but that doesn't take away the fact, Honourable Speaker, that there are many constituencies with similar questions and similar financial needs.
Then it's up to them to bring it. Okay, proceed, please.
Allow me to re-emphasize that government, through the Ministry of Agriculture, Water and Land Reform, has made tangible studies in the development of the agricultural irrigation projects in the country. For instance, in the early 2000s, Cabinet, through a decision 1806-08-02-04, mandated the Ministry to embark on an intensive agriculture through investment in large-scale irrigation projects along the perennial rivers and dams. The development objective was to achieve increased food security, increased contribution to a gross domestic project, job creation, exports, and attracting private sector investments in local participation in crop production and sector. To date, among other green scheme projects such as Itunda Phase 6 and 8, Musese small-scale farmers component, Sikondo, Uvungu, Dairy, Ndonga and Linena, and the expansion of Kalambeza rice in the Zambezi region have been completed, and these have reduced the import
members, sorry, let's try to do our level best to allow the minister to finalize the questions. Please. Yes, proceed, Honourable Minister.
Thank you. So we have in the Zambezi region, we had in fact two projects. We had the Kalabeza project and we had Katima Farm. Katima Farm was put in jeopardy by the local people. They killed the farmer that did the farming and destroyed the infrastructure on Katima Farm. It is completely destroyed and there is nothing left to do. Kalambeza ran into misfortunes due to mismanagement by agribusiness. We are now picking it up. We have leveled it and we have brought it to Cabinet with an allocation from the Minister of Finance to plant both sugar and rice in Kalambeza. In addition, the government is implementing various programs such as dryland crop production, conservation agricultural program, and horticultural development programs through which the ministry provides subsidies and extension services to small-scale crop producers in the household. In the Zambezi region, we have a specific project of women who produce fruit and use indigenous fruit to make jam and compotes, and that is a very successful project where we add value to raw materials and engage small-scale entrepreneurs. Traditional authorities in the Zambezi region have made land available for agricultural schemes, demonstrating their commitment to national food security. However, there has been no visible action from the ministry to utilize this land. We are very thankful to the traditional authority to have made that land available, and we were in continuous contact with them. We explained that if a traditional authority makes available agricultural land, that intent, with a description of the piece of land, must be brought to the land board. The land board must then verify the size of the land and the demarcation of the land. and bring the recommendation to the Minister of Finance that that piece of land can be designated as agricultural land. The legal effect of that is that once it is designated as agricultural land, its land use is determined. It's not anymore customary use, it is now dedicated to land use only. And from that point of view, we can then develop a project with public money. We cannot develop a project on the mere promise of a piece of land, which is not demarcated, which is not surveyed, and which is not gazetted. That security of tenure is absolutely necessary for the state to make that possible. So that engagement is ongoing. I don't want to go into the detail here, but we have advised the traditional authorities to follow that. I have been in contact with the land board on several occasions to say when you get a request from a traditional authority to designate land for agricultural land, please do so quickly because we are in desperate need of agricultural land. We are with you when we say we have a water resource, we have a land resource, so we have the basics for food production there. So that is where we are. At the moment, the pockets of land identified by the traditional authorities through the land board following the process were 5. We have Liselo. It was from the Mafwe Traditional Authority, and it is 426 hectares. We have Liselo 2, also from the Mafwe, which is 4,581 hectares. We have Shakana from the Mashi Authority. It is 955.9 hectares. We have Kongola from the Mashi. It is 13,057.7 hectares. And we have got Lianchulu from the Mayei, 615,000. Those are the ones that were designated, not yet. They need to be gazetted still, but that is where the process is to designate. The other pieces of land that you have mentioned are very generous offers, and I advise you to follow a similar process so that we can designate them as agricultural land, and then we, of course, must consult the stakeholders, which is the traditional authority, which is the land boards, how we develop the agricultural potential on these lands. Now, you have asked about public-private partnerships. That is the next step. If we have a designated piece of land, if we have the agricultural potential sorted out, we can then approach in a PPP fashion to develop the project. So it's a very good suggestion, and I thank you for it. Question 8 was, many farmers in the Zambezi region lack access to trading and financial support. I'm afraid to say that that is true for many communal areas. Many farmers have not enough support structures in place. We have in the ministry now received some funding to conclude, improve and finish projects of regional agricultural centres, both for crop production and livestock production. And we have requested in our plan an increased staff component and increased financial resources for improving our extension services. With climate smart agriculture, that is part and parcel of our paradigm shift in agriculture. We have accessed the funds, some funds of the Climate Investment Fund, and in cooperation with Japan and UNDP, we have engaged in several climate smart agricultural projects. We have also had the benefit of funding from the Environmental Investment Fund locally for climate smart agriculture, and we are pursuing it. It's a correct assumption that that needs to be stepped up in the future. Question 10, almost the last one. How does government prevent continued underutilization of the land? I believe the answers above indicated how we're trying to prevent underutilization of land. It is by designating land and then develop projects on it. In parallel to that, we of course want to also develop small-scale farmers in their own right in a custody setup, so we will also follow through with that. Question 11. Without a clear timeline and measurable targets, the potential of the Zambezi region will continue to be wasted. Well, maybe at the moment we have not fully utilized it, but it is not fully wasted. We have built the abattoir in Katima Mulilo. We are getting good results from the livestock sector. We have a mill in Katima Mulilo where we mill maize. We have good results from there. So we do have some benefits from development in the Zambezi region, which other regions don't have. There's no other regions where we have that type of success up to now. And I think we must just pursue and increase production levels and then increase processing ability both on the livestock and the grain side and create new economic opportunities for the people in the regions.
Okay.
So I have summarized drastically, but I thank you very much for the question.
The questions are too long. Okay, the time won't allow any follow-up. In the future, try to trim your questions. They are too long. Summarize. With that, the House is adjourned till Monday, 14:30. Till Monday, 14:30.
This is NBC One. It's ours.